I'd like to turn now to the third stage. We have called this the qualification hearing. This is now after the paper review, and the matter is going to be heard by the court. We feel this is the first time where there's a right to counsel. There are obviously fundamental rights involved here in terms of the resentencing, and we feel that the defendant does have the right to have counsel. We view this hearing in two parts. The first part is the confirmation of eligibility, and then the second part is a determination of dangerousness. Turning first to that confirmation of eligibility. Remember, up to this point, there has only been a paper review by the court. The statute says that at this hearing, the court is to determine eligibility under the statute. This is an opportunity, I think, for the prosecution basically to provide additional information to the court that might indicate that the initial paper determination was flawed in some respect. Perhaps there's some additional information about priors that weren't identified or things of that nature that would disqualify the defendant. So the court is going to have to review that to determine whether the statutory basis, the pure statutory grounds apply, and that there's no exclusion that would prevent the reconsideration of the sentence. It may be that there's other evidence offered. It's a little unclear. For example, if the district attorney is intending to show that the defendant acted with intent to cause GBI, is there an ability to call new witnesses, recall the victim, for example, to give testimony?
What the standard of proof is going to be?
There's all sorts of questions there. I think the only guidance that I can say for this hearing right now, the most obvious guidance is just, again, to look at the words of the statute. This is a resentencing process. It seems to me, at basic, what would be admissible at a sentencing proceeding, an original sentencing proceeding, would be admissible in this proceeding. Whether you can bring additional witnesses in and so forth, we'll have to see. I think that's somewhat of an open question.
That question's going to include whether or not you can introduce hearsay, also whether the record of conviction that's used to prove up strikes might be the limitation on it. It is an open question, but I think largely it's just going to apply to that nebulous phrase of whether or not the defendant intended to inflict great bodily injury. Do you agree?
Yes, that's really the only area of the disqualification that frankly is a bit fuzzy. The rest are based on strict statutes, which are much clearer. It's important, if you can make this decision first, it could be decisive. As the last bullet point indicates, that if it's not confirmed that the defendant meets the statutory eligibility, you deny the petition, it's done. You don't have to get into the more nebulous issue of whether the resentencing would create an unreasonable risk of danger to public safety. So it provides sort of a subcut in this hearing, which may be useful. The second stage, assuming that the defendant is statutorily eligible after the full review of the record, is whether or not there is a determination that the court makes that the person presents an unreasonable risk to public safety if the resentencing occurs. This is obviously a safety valve that notwithstanding the paper qualification of the defendant, the court is given one last opportunity to exercise discretion, at least in a limited way, to determine whether there is simply an overriding concern about the defendant's dangerousness that should cut off any relief. It's important to understand that if the defendant does qualify after the paper review of the record, the court must sentence the offender as a second strike offender unless this dangerousness is shown. I hesitate to use the word presumption. It's not quite a presumption, but obviously the language of the statute is very strong. It's must sentence unless this is shown.
Not the full discretion that might ordinarily attach to such a hearing that considers a multiple history and factors.
Yeah, I think it's a very, very narrow bit of discretion that the court is given, although it's obviously extremely important. The court will have that discretion to make that finding. The statute outlines the things that courts can consider. The court can consider, obviously, the criminal history of the defendant. The court can consider the disciplinary record of the defendant while at CDCR. Here is a situation where it will be helpful to have the parties of the court obtain the defendant's 969B packet, for example, which contains lots of information about the conduct of the defendant in prison. Some of this information, if it's based, for example, on mental health records or things of that nature, may require a subpoena ducis tecum. But the Department of Corrections is prepared to respond to this information request and to give it to the court. And then there's that final catch-all phrase, any other relevant evidence. So it's a very broad brush that the court can sweep through to gather information in terms of this resentencing decision.
Relevant to whether or not the defendant would be an unreasonable risk of harm.
That's correct.
It is a catch-all phrase, and it's going to be interesting to see what courts decide show that.
That's correct.
In terms of the factors.